the YouTube live right now, and then we can start.
Hi, Miss Gali.
No, I feel so old when you told me that. Gali, just Gali. I am a friend.
Okay.
Gali, Gali, Gali. I guess that today we will not. Today we want to be.
Hi.
Hi, hello. Okay.
How are you?
I am fine. And you at the office? Still?
I'm not in the office, but we have a meeting about a work we have to do.
Okay, but you are not a couple. Or you are a couple? Because yesterday,
no, we are not.
Yesterday Esteban was driving, and then
we are not a couple.
I start to connect things because Esteban yesterday was driving, and then in the other speaking session, Paula told me like, "Oh no, no worries, my boyfriend is driving. I am arriving home." But I never. No worries, we accept relationship here.
No.
Okay, so you would be together in the same place and the same computer, and you can see like the slides there without problem, right?
Yes. Mm-hmm.
Okay, perfect. So we will start right now with the session. Okay, give me a second that I am connecting the PowerPoint presentation. I don't know why it's not working. Give me a second. We're having technical issues. Okay. Can you please confirm that are you seeing my screen right now? Now? Can you see it?
Yes.
Okay, perfect. So before I start with every area of law, we need to start from some basics, right? That is my plan for today. So we will start because we have a lot of things to do. The last session that we had, we finished here, I guess, that is submitted. And we talked about this term that is commonly used for finish and a stage or a space in every process, proceeding, or trial, right? Es como para decir que esa etapa ha concluido, ¿sí? Esa etapa probatoria, ese momento probatorio. Un ejemplo, a ver, está la demanda, luego vamos a tener una audiencia inicial, luego una audiencia práctica de pruebas y una decisión, ¿sí? Cada vez que yo imposibilito como juez a las partes para que presenten determinada prueba, determinada alegato, determinada situación, en cada una de estas etapas, y yo cierro ese momento, el abogado ya no puede volver a presentar aquí, o sea, en el siguiente. En materia penal sería como, en el caso de Colombia, sería como, yo solicito las pruebas, como fiscalía, etcétera, y luego tenemos ciertas audiencias, ciertos procesos, como puede ser la acusación, la preparatoria, en la que las partes van soltando sus pruebas. Cuando ya llegamos a la audiencia de práctica de pruebas, finalmente puedo llegar a esa audiencia de práctica de pruebas fue porque todas las etapas anteriores were submitted, ¿sí? Porque terminaron satisfactoriamente. Si yo no solicité una prueba en el momento A, yo no la puedo venir a solicitar en el momento B, C o D, porque el procedimiento me habla de un momento específico. So, this is the way that they call it in English, right? The stages can be submitted, the moments can be submitted, but also the proofs, the allegations, the final decisions, okay? So the example that I gave you here is I cannot say my argument in a moment that the judge didn't allow me. but we are not just talking about the sense of humor of the judge. We are talking about the proceeding. And the proceeding exists in all the codes that we get, right? If we are talking about civil law and labor law, any cases, right? Es la manera en la que nosotros cerramos un argumento. Y cuando más se utiliza es cuando el juez pregunta, it is submitted, es como terminó su alegación, hermano, ya podemos seguir a pasar a lo siguiente. ¿Ok? We have a lot of things to say about the way that we call the lawyers. The first one is the lawyer. The second one is the counsel. All of them, in the most of cases, are synonymous, and we have some specific ones where we talk in different countries, and I will explain you later. So lawyer, counsel, counselor, it's so useful or so used and common in US, and the attorney or attorney at law, solicitor, commonly used in UK, and barrister in UK also. And the advocate is the most common one. You can use it in all the countries. What happened? You cannot stay in you cannot see the presentation clearly in the same computer?
Sorry about
Okay.
that.
That group, I need that group separate. It's just a joke, it's just a joke. Okay, then we have the advocate that is commonly used in Scotland. But as I told you, all of this is the same. And prosecutor, that we saw that already. Prosecutor is commonly used by fiscalía, el órgano encargado de la investigación. And for example, in my country, we have la Fiscalía General de la Nación, and the main or the manager, the most important one, que es como el fiscal general de la nación, la cabeza, we can talk about the prosecutor also. So it's not just, no solamente solo los fiscales, sino también como quien tiene la representación, la cabeza principal de la entidad, también lo llamamos así, prosecutor. Okay? Perfect. Other thing that is so important here is the bar associations. Do you know what is the bar? Some of you can tell me.
Yes, we know.
Perfect. Carla, do you know what means the bar?
No, I'm not.
Okay, no worries. In our countries, it's not so common that we use the bar. In Bolivia, yes, they use it, like the college. But in Colombia, we don't work with a bar specifically. We just have to present some exams at university, we get graduated, and then after that, we just have to present of papers for get our professional card. And this entity oversee us, check that everything is going good with our profession. If, for example, I do a bad practice working, my client can go and sue me or advise that entity that I am doing bad things, and they will cancel my professional card. This is one of the things that the bar associations do. They oversee relationship between lawyers and clients or companies, and basically they check your behavior, that your behavior, it's okay and it's everything all right.
Okay.
But in other countries like US, UK, Australia, or Canada, they have an exam, a specific exam of the bar. And you will always see this like in series. I was talking with one of you yesterday about Suits. And basically the trauma of Suits is that one lawyer, did you saw Suits? ¿Alguno de ustedes vio la serie? Perfect. Carla, la serie. Todo abogado pasó por esa serie. Bueno, tienes que verla, es buena. The thing is, like, one guy that has an amazing memory, and sell drugs. One time just stay in a hotel, like selling drugs and whatever. And he was like so intelligent, and he could figure out that some police was in the same building, or were in the same building. And he started to run and find like interview for become a lawyer in a huge law firm in US, whatever, or UK, I cannot remember. And the thing is that he always wanted to be a lawyer, or become a lawyer, and has an amazing memory, but he never studied just for the drugs. Basically, there started trauma. When you work in this kind of law firms, and when you work in a specific country, the most important document that you need to get with you is the exam from the bar, right? You prepare the whole career, 3, 4, 5 years, just for that exam. If you lose it, you kind of lose the possibility to become a lawyer. So it's so rude and so specific. And if you have any score in every state, for example, in US, that is a federal country, you have a specific score if you want to work in one of these huge law firms. So they do the exam, and they can tell you if you can become a lawyer. Basically, then in the same series, just for not cut the idea, this guy has an amazing memory, and he presented that exam for other people, just like a fraud. But all the knowledge was in his brain, and basically he started to work for the law firm, and the series is good. At the end, it's like quite boring because it's always the same, but it's really good. I like it. And it's also good for get a little bit of a specific vocabulary. The most important thing here is like the barrister, they can always have complete control about your behavior. If you do good things, everything will be all right. But if not, they can cancel your license. So a barrister is an independent specialist advocate and advisor in law. Their highly competitive training, together with their specialist knowledge and experience, can make a substantial difference to the outcome of cases. Cuando nosotros hablamos en Colombia del colegio de abogados, que es como lo que más parecido tenemos al bar, a la barra, nosotros como firmas o como personas naturales o como abogados independientes, consultores, asesores, nosotros podemos pedirle conceptos al colegio, ¿sí? Podemos decirle, tenemos este caso, necesitamos una reunión, y que los más capos del tema asociados al mismo colegio nos ayuden. Ahí no sé si sería diferente en sus países. En el caso de Australia, que fue el ejemplo que yo estoy citando en este momento, ellos utilizan a los mejores abogados que pertenecen a la barra como un órgano consultor, y también lo utiliza como órgano consultor la corte o las cortes, ¿de acuerdo? Siento que es muy diferente en cada sistema legal. Puede ser muy diferente en México, es diferente aquí en Bolivia, es diferente en Ecuador. So, in this case, we just need to get the association of that. Bar association or bar, we are talking people that oversees relationship between clients and lawyers, people that can counsel or license, but also they can consult and they can answer questions about all the proceedings that we need to solve in our daily life. What is the difference in this case? A barrister is the best known for their advocacy before the courts, but it's true to say that they can solve a dispute or resolution, both judicial, that can be before courts or tribunals, and non judicial through negotiation, mediation, or arbitration. They are so known, and they have like all these goodwill. Do you know what means goodwill? All of you that works in corporative law.
Voluntad, consentimiento.
No.
It's
Goodwill.
like a name, like known name of a company or something.
Yeah, it's more for that. Yeah, something more. Who give me more?
No sé.
Okay, goodwill es como good y will como el futuro. Se escribe así. Good espacio will. And we will show it in our lessons, but I want just for understand this. En español, para que Carla ahí, y luego vamos en inglés. El goodwill es un ítem súper relacionado con el derecho comercial, en el cual nosotros podemos identificar una marca, un sector, podemos identificar...
¿Cómo te dicen ustedes?
Ya los escuché ahí hablando. Podemos decir que el goodwill es el buen nombre de una compañía, pero ¿para qué nos sirve? O sea, ¿cómo lo relaciono? El goodwill es una materia, es un específico caso de indemnización en el cual yo, como quien defiende, como quien acusa, puedo solicitar un perjuicio. Y les voy a dar el ejemplo más claro. Yo vendo empanadas de Gali en la esquina. Y resulta que me demoré 15 años construyendo este nombre y durante esos 15 años toda la ciudad sabe que yo tengo las mejores empanadas de la ciudad. Y ante tal éxito, el dueño del local comercial que yo estoy arrendando, decide, Gali, dame el local, porque lo necesito, porque lo que sea, quiero poner una tienda de zapatos. Aparte de pagar todas las cláusulas contractuales por el cambio repentino en ese contrato, vamos a decir, porque no me hizo el preaviso con tiempo, etcétera, un ítem que yo puedo reclamar en todo lo que tiene que ver con derecho comercial o con materia empresarial es todo lo que a mí me costó ganar un reconocimiento o un buen nombre. Y todo lo que me costó a mí en temas de marketing, de publicidad, de trabajo, lo que sea, todo lo que me costó a mí posicionar ese lugar en específico, esa esquina, como mi esquina de empanadas, que ahora va a ser una esquina de zapatos. Eso es algo que es un daño inmaterial, ¿sí? Porque está como en el espacio. Pero yo puedo reclamar que todo ese tiempo que yo me demoré construyendo un buen nombre y en un momento a otro se me vino abajo, es una materia de indemnización. ¿Ok? So, goodwill. We are talking always about goodwill in damages. Because this is just an example for make it clear, but when we're talking about huge companies, this can affect too much. Okay? So, I cannot remember why we're talking about that. This bar or the barrister, they can solve these kind of issues and they can solve by a judicial way, like giving concepts to the court or tribunals or judges, but also in a non-judicial way. You can arrive to these barristers and say, okay, this is the issue, we need to solve it, and okay, the taxation will be this and this, just for pay for the specialist that will take a decision here. So for that reason, they are like the top lawyers in every matter. And if you want to solve a labor issue, you will be connected with some lawyers that are specialized in this area. And like this with other countries, with other areas. Why? Because when we are talking about justice, we know that our legal systems are really bad. And for a company, it's always more useful, pay a little bit more just for a tribunal in arbitration, mediation, or one kind of mediation because of the time. If I am representing or I'm a defendant of a company and the time that I need to wait for a final decision is 5 years, that represents a lot of damage in my accounts because time is money. So for that reason, if I have to wait 5 years for a decision, I prefer to spend a little bit more and kind of buy the justice. I know that sounds quite rude, but it's the reality. They do it a lot. And especially when we can solve these issues by negotiation, arbitration, or other rules that we will cite later. So other thing that can do this kind of lawyers is kind of check the outcome of every process. They can give you a percentage or they can give you light in a process, and they can prevent or they can help that you didn't start something that maybe don't have future. They are like the lawyer of the lawyers. They advise you. So with all the training and experience, they can anticipate the range of likely outcomes, los resultados probables de una negociación, de un arbitraje, de un proceso de consultoría, de una licitación, ¿sí? Esto en nuestros países, en Colombia, por ejemplo, lo hacemos siempre, la llama un amigo, el que más sabe de una vaina, So we can talk that they are the barrister, right? They can anticipate the range of likely outcomes, los resultados probables de X o Y cosa, and work with the solicitor and their client to choose the most appropriate path. So it is helpful to involve a barrister at the outset. In Australia, Canada, and UK, you can go with your lawyer to the barrister office and say like, hey, we need just an advice in this thing, how we can solve it. So that means that I will change the lawyer, means that this barrister, these specialized people would give us advices, and I can be with my client here, right? We can go together. And also, this helps to clarify the management of the entire dispute resolution process and empower clients to make informed decisions. So remember that an early good advice can prevent or can help to the client to take other kind of decisions and don't maybe waste money with witnesses, with notifications, transport, and the whole stuff that is involved in a big trial. And this barrister can solve it by other route. That means that you are paying. In Australia, it's completely free. So you are paying your lawyer, and your lawyer can advise you to go there. It's not like in other countries that, oh yes, I know about this process. Give me a moment, and then you call your friend, how we can do this, and etc. Okay. And the term counselor is commonly used interchangeably. As I told you, all of these are kind of synonyms. In one countries you can use it more, but means the same. So a counselor is commonly used interchangeably with attorney, except in a few states where the terms refer to lawyers and different ranks. This is the case of the US system. They have always a range for everything based on experience. That happens so much in the law firms. You have junior, senior, manager, CEO, okay? So they classify the lawyers on ranks and base it on experience. In such states, an attorney may become a counselor only after practicing law for a certain designated period of time and passing an additional examination. For example, in our law school, we know who was the most expert professor in some area. That is the difference between professor and teacher. A teacher can do it like everyone, but a professor has like a specific range at university. It's like means more respect based in their knowledge. So basically in such states, in the United States, of course, you can call a counselor like at the top of the lawyers, in the court, in the school, at the school of law, everywhere. Like the counselor is like the head of. In my case, on the law, in my law school, they like the oldest one, the one that had like the one that was, I don't know, judge for 40 years, and this old guy can solve all your questions so easy. He will be a counselor if we were in the United States, right? And one of the most common ones are the trial and consulting attorney, como un abogado litigante y consultor. Sería la manera linda de decir y autoproclamarnos si estás dedicado en el litigio, ¿verdad? Entonces, por ejemplo, Esteban Herrera, y abajito, trial and consulting attorney in civil proceedings or commercial proceedings or factoring proceedings, as you told me yesterday. Es una manera en la que tú es como un abogado consultor y litigante, asesor. Pero es importante que comprendan cuándo podemos utilizar counselor, porque nuestra cabeza, solamente porque son palabras muy similares, podríamos decir que estamos hablando del counsel, when we're talking about counsel, estamos hablando de un canciller, o que estamos hablando de alguien que trabaja como en el consulado, solamente por las asociaciones gramaticales, ¿sí? Se parece mucho la palabra, pero no, tiene un significado completamente diferente. So when we start to talk about contracts, because we will start to use all these terms in public and private, this is just basis, we need to talk about all of these matters. First, intent. This is the most important thing. Intent. Beginning with the intent to make one, an offer and considerations for both sides. Agreement on the specific elements of a contract leads to acceptance, at which point the contract is legally binding to both parties. Entonces, lo principal que tenemos para hacer un contrato, la intención de crear uno, la oferta, las consideraciones. Entonces, la intención, quiero comprar un celular, la oferta, te vendo este en 1000, las consideraciones, uy, no, tiene la cámara dañada, el cargador no le está funcionando, me va a tocar ir a comprar otro cargador, 900, ¿verdad? Cuando yo voto 900 y la otra parte dice, sí, 900, we are creating the acceptance. And when we have the acceptance, in that point, is legally binding. A partir de ese momento es jurídicamente vinculable o vinculante a las dos partes. ¿Ok? Legally binding. No se preocupen, yo sé que todos tienen maneras de aprender distintas, pero todas estas presentaciones yo se las voy a enviar para que ahí no relax. Si quieren tomar notas, súper, pero todo esto yo se los voy a enviar, así que no hay problema. Entonces acá tenemos 5 palabras, 1, 2, 3, sí, 5 palabras o expresiones. Intent, offer, consideration, acceptance, and legally binding. Jurídicamente vinculante. Esto no se les vaya a olvidar nunca, por favor. An example. The conclusion of a legally binding international agreement with the above mentioned contents. Es un ejemplo de la vida real. O sea, si no es OEA, es corte, es sistema. Está tomado de ahí para que vean cómo funciona como en un contexto, en un contrato. Entonces, celebración de una corte internacional jurídicamente vinculante con los contenidos anteriormente mencionados. Creo que es de una declaración. So that is the way that we use this expression, right? Conclusion of a legally binding international agreement. But a contract may also be treated when one party, esto es súper importante. We will say party when we are talking with an US accent, and we will say party when we are talking with UK accent. So depending where comes your clients, and it's a synonym from go and party hard. Never forget it. Las partes de un contrato, las partes de una negociación, todas las partes que hablen de cualquier cosa. También para tratados internacionales, para acuerdos, para negociaciones. Siempre sutanito y merenganito son partes. And we will say party or party, depending of the accent that we need just for our clients. So a contract may also be threatened when one party does not fulfill its obligations, which can lead to repudiation. El repudio de un contrato. Esto aquí comienzan los problemas de qué país somos. No sé cómo funciona en México, cómo funciona en Ecuador, cómo funciona en Bolivia. En Colombia, para yo poder tener la terminación de un contrato, no es tan común que le digamos repudio, pero sí tengo que dar aviso a la contraparte, ¿verdad? Cuando yo digo, mire, hermano, de verdad no me está sirviendo porque todas las funciones que está haciendo, que yo lo estoy contratando a usted para hacerlas, las termino haciendo yo porque están mal, ¿sí? Es como esa primera comunicación de que no se están cumpliendo a manera cabal las obligaciones para las cuales yo estoy firmando esta negociación o este contrato, ¿verdad? So, repudiation. And when two parties under a contract cannot agree, they may try to settle their dispute through a process of arbitration. Settle their dispute. Are you seeing? When you move the computer, I am like moving with you. Okay. Settle the dispute. This is a really important term. When we want to use it, I put it like on a slide. Settle a dispute means finding a solution to their disagreement in referred to as settling the dispute. If I need to solve one issue, I can say like, hey, we need to solve this. Or I can say, hey, Carla, we need to settle the dispute or a dispute. We need to fix this. So how we can do it? We can take like a judicial way or a non-judicial one. And so we can try to do a mediation. We can pay by a counselor, we can go to the arbitration camera, we can have like judge in peace. I guess that is also known. In Ecuador, maybe you get like this figure, como juez de paz. ¿Tienen? ¿Lo usan? ¿No lo usan? ¿No? Bueno, en mi país, en México, bueno, Carla, en Colombia, les voy a contar, en Colombia las comunidades y como los alcaldes, las grandes ciudades, o sea, tenemos muchas divisiones territoriales, pero tenemos alcaldes municipales. Y los alcaldes municipales designan cada periodo de tiempo, cada 4, cada 3 años, a los jueces de paz, que son como el viejito querido del pueblo, ¿sí? El viejito querido del barrio. Y que tiene de una u otra manera una sabiduría para solucionar este tipo de problemas. Es una vía no judicial de solución de controversias, pero es como gente muy respetada en la comunidad que puede solucionar esos problemas de hay humedad en la casa del vecino y me está dañando la nevera, ellos tienen que pagar, no sé qué. Antes de iniciar un proceso, se acude a los jueces de paz, entonces ellos buscan la manera como de mediar, de páguele aquello, páguele lo otro, y la gente respeta esas decisiones. O se va a la madre y se agarran y pasa todo lo que sabemos. So if this doesn't work, one party may attempt to sue the other in court. Demandar, sue. Sue. I saw this with one of you yesterday, I remember. I need to sue them. My company needs to sue them. We need to make the sue, right? Sue, demanda. So to sue the other in court, hoping to be awarded damages in the case of a breach of contract. We have here a lot of information. So the first thing, awarded damages, indemnización por daños y perjuicios. Okay. ¿Cuál es la diferencia entre damages that we saw the last session, like 2 days ago? Damages son daños y perjuicios. Y awarded damages puede ser la indemnización, pero también los daños y perjuicios que están probados en el proceso. Que la diferencia entre damages or damage, that I'm asking for indemnization of all the damages, but also I can say awarded, and I can, for example, in a final request, I can tell to the judge something like that. Judge, in this case, we have awarded damages. So I want to ask you that you do, or that you put clear in the sentence in the space A, B, blah, 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 right? Just for clarify the situation. And the breach of contract that I will explain you later, but I can do it right now, es el incumplimiento contractual. El incumplimiento. We have here a breach of contract. It's like the way that you need to discuss it with all your clients. Oh yes, we can apply the breach of the contract in our country just for preserve the security of your company, just for try to claim for indemnization, just for represent of your interest. We will claim for a breach of contract. This one, remember, party hard. So each party may be a person, a group of people, or businesses, or another type of organization that can attempt to a case, a court case, a process, proceeding, negotiation, arbitration, or etc. Settle a dispute. I just told you that. And we have this, that is the elements. Esto nos gusta mucho a los abogados, Carla, lo siento. A nosotros nos gusta tanto A, B, C, D, D. Parágrafo A, el parágrafo 1.1 dice. Entonces, breach of contract. ¿Cuáles son los elementos? Primero, necesitamos la existencia de un contrato que sea válido. Obviamente, yo no les voy a dar una clase de derecho, pero cada quien va a viajar por allá a sus primeras clases de contratos, y en el caso de Carla lo voy a hacer súper rapidito y en español. Un contrato puede existir y no ser válido. Por ejemplo, si una persona no tiene la capacidad jurídica de actuar, un menor de edad, puede que trabaje, pero su contrato laboral no es válido. Sí, bueno, teniendo en cuenta que pueden haber unas especiales circunstancias, de si tiene una autorización de su mamá y después de los 16, bueno, todo esto. Pero en específico hay unos requisitos en la ley, en los códigos, para que un contrato sea válido, ¿sí? Que la persona no haya firmado el contrato borracha, que la persona no haya firmado el contrato drogada, que yo le vendí la casa al perro. ¿Sí me entienden? Entonces, la existencia, la primera regla que necesitamos es la existencia de un contrato válido, ¿no? The existence of the valid contract. The plaintiff performance or tendered performance. Esto es como el acto del demandante, el acto del demandado. Like the performance. It's so useful, this phrase and this way to understand it. I will give you an example. If I have a contract and everything is good with the contract, I don't sign it drunk or drugged or whatever situation, is valid, the contract. When we talk about a plaintiff performance or tender performance, we are referring to all the actions that makes that possibly we can have the breach of the contract. If I am paying the rent and I am doing out of the dates that we give, like it's commonly used that we use it in Colombia, the first 5 days of each month that we need to pay for rent. So I start like to have issues with this case. It's the 9th of the month and I'm not paying. I am maybe giving excuse to the owner of the real estate or the house or whatever that I am renting. I am starting to do some specific behaviors that can finish with the breach of the contract, right? I am having a behavior that is not in the same route with the contract that we signed before, but is not the breach of the contract until I communicate the other part. ¿Ok? Esto es súper importante, porque yo me puedo demorar en el pago 8 días y después pagar y todo sigue bien y no ha pasado nada. Pero en el momento en el que a mí me comunican el incumplimiento contractual, que es the breach of the contract, comienza el demandante a tener ventaja, es solamente el ejemplo que les estoy dando, a tener ventaja sobre mí en materia probatoria, que es con el tema de las comunicaciones para la devolución de bienes inmuebles o etcétera. And the last thing is the damages, that is the result of the breach or of the breach of the contract. We can manage like an example and then will be more easier for all of us. So we will talk about the rent of the car, right? Of one car. We do a rent car because we are traveling, all of us in Cancun, having fun, etc. The existence of a valid contract, yeah, we sign it, we pay it for use the car, we prepare everything for go and pick it up and then go and leave it in another city and etc. We do all the process. Then we have one issue or performance. We arrive late, we don't pick it in the same time that they told us, and we don't return the car in the same city that they told us because we have something. So one of us get drunk and we need to deal with that and etc. We're just getting late. Until there, nothing happens because we pay it and maybe we have to send or stay there in the office at 3, at maybe it's 5 and we didn't arrive. Okay, something happens. Maybe they start for it something, they stop for it something, sorry, or they went to other place. Maybe we have to pay a little bit more for this issue. We can like solve without problems. But the results that we were driving at some part of Cancun and we crashed other car, right? And for that reason, we didn't arrive at the time that we accept before. So that is the element number 3, the breach of the contract. Because we didn't arrive, we cannot solve it just paying a little bit more for a couple of hours. And of course, all of these depend of the clauses, de las cláusulas. Todo depende de lo que hayamos pactado en el contrato. pero vamos a decir que ya hay un incumplimiento contractual específicamente, porque están comiendo y sin compartir. Yo me doy cuenta de todo. Okay, and the third part, like this, the specific element of this contract is that we cannot solve, like we cannot return the time and try to be there at 3, that was the time that we planned before, because now we have to deal with the other car, and then we have to try to pay to them for the damages, and we were drunk, and then arrived the police, and a lot of situations can happen, right? What is the damages? The car, now we have to paint the car, we have to go to a mechanic and they can solve it, right? Then how they will ask for all these damages, how we can fix it. We will talk about indemnization or negotiation with them. We'll stop here. We can talk about an indemnization. We can solve it by mediation or arbitration. But then at the end of the day, if we cannot solve it in that way, they will sue us. And they have like all the elements for sue us, all the proofs. Okay. I finished this session so early, so we will start to get in advance because I guess that will take me more time. So no worries, we will continue. This topic is so basic. Until now, you have some questions? I want to know it. No, is everything clear? Clara, is everything clear? I know that it's quite hard to understand these kind of things, but I don't want to talk about the breach of the contract if you really don't manage how this kind of issues works in Spanish. So every time that you didn't understand something, I will please ask you that you stop me and say, hey, Gali, I didn't understand this. Can you please tell me what the hell it means? And thank you.
But I only have a question about
Tell me.
how you call the person that the counselor or the consejero in the diplomacy.
Yeah.
There is the ambassador and el ministro consejero. With the name that you gave, I had the question how to call, and also the cónsul. El
cónsul. Ok. ¿Cuál fue el primero que me dijiste? ¿El ministro qué?
Consejero.
Bueno,
Consejero.
el ministro consejero, en mi país eso no existe. En Bolivia me atrevo a decir Nicolás, no estoy segura si Nicolás es también boliviano, ténganme paciencia con los nombres, pero me atrevo a decir que aquí tampoco hay. Entonces, when we are talking about, no sé cómo hacer switch, when we are talking about the counselor, también en algunos países se habla del like British Council, es un ejemplo. Está muy relacionado con los consejos, desde el área que tú me dices, sería una manera de decir como un sinónimo del ministro consejero. And then I need to type this, and it's the right. Podemos decir ministro, it's like the chancellor. Podemos hablar de un ministerio, podemos hablar de todo este tema de la diplomacia, pero si tú dices chancellor, también estamos hablando del me suena mucho el council, me está sonando en inglés, del canciller. ¿Listo?
Listo.
Entonces, como la manera de hablar del consejero. Y cuando hablamos de los ministerios, nosotros en Colombia hablamos de los asesores. Right? So, we are talking about the presidential counselors, como los asesores presidenciales. ¿Sí? No sé cómo funciona en Ecuador. ¿Tienen ahí micrófono? ¿Tienen ustedes eso del ministro consejero?
No, we don't have.
No.
Okay, bueno, yo tampoco, nosotros tampoco. Pero you can talk in the way that I just told you. And the ambassador, okay? So as we finish early, we will start to go in with the topic with the next topic. Moving on from the basis, we will start with the huge topic that will take us a couple of weeks, that is international law, okay? All these bases, we can also use it in private law, that is your area. The most of them you can use it in private law. And some specific, that is just about the behavior of nations that happens. So when we talk about international law, we have a lot of different circumstances that can be involved in this issue. The first one, the non-state actors. I know that all of you work in the same area, so don't be a skeptic. But non-state actors does not just mean the countries or in all diplomacy sector, the one that represents the countries. We have in non-state actors also a lot of organizations or companies that can help to the development of the nations. As you know, for example, in Latin America, we have a lot of organizations from UE that they invest in projects just for solve some kind of issues in our countries. We can work with women, we can work with child, we can work with indigenous communities, we can work with the environment, and they are understood as non-state actors. They have influence in economic, political, or social power, and influence at national and in some cases international level. Some definitions include non-governmental organizations as ONGs or NGOs or todas estas non-profit organizations, que también lo conocemos mucho en español, que son las organizaciones sin ánimo de lucro. Okay, and we have transnational corporations like trade unions. Esto es muy importante porque esto lo vamos a ver después en labor law, que son los sindicatos o los gremios a nivel internacional. Algunas instituciones religiosas y grupos étnicos. So some definitions include non-governmental organizations, transnational corporations, trade unions, and religious institutions or ethnic groups. Okay, non-state actors. What is the common thing between all these models? The first, the capacity to act, the capacity to enter into a relationship with other states. And this is including like on the range of importance that you are having in one community or one sector, that in the case of Europe, for example. But also the capability of a subject of the law of possessing international rights and duties, deberes. The duty of my client is this. The duty of our company is this one. The duty, el deber. Como, no sé, nunca jugué, pero yo lo asocié en su momento a like Call of Duty. Como un llamado del deber, ahí solamente una ayuda técnica. But also they can have the capacity to maintain the rights and bring in international claims. This is so important when you're talking about an international organization, because if you cannot present until the community a specific behavior and a specific situation that is happening, so you just need to have like voice and vote in the community or at the community. We need to have the capacity to act, right? And that capacity to act is involved the capacity to present some international claims, depending of each community that we were talking about. What is a claim? Una queja, una denuncia. And impeachment es un término súper utilizado en materia de legislatura. cuando se hace una pérdida de investidura, que es el proceso que se realiza en mi país, que nunca funciona porque la comisión nunca lo vigila. En Colombia le decimos como de jueguito la comisión de absoluciones. Básicamente ellos lo que hacen es estudiar el caso, algún congresista, algún senador que estuvo envuelto, por ejemplo, en temas de corrupción, estudian, no encontramos pruebas, pum, cerramos, se acabó, ¿sí? Este proceso de pérdida de investidura en mi país lo llamamos impeachment process. Ustedes, cada uno en su país, tendrá una manera específica de llamarlo. Cuando yo hago que un funcionario público pierda su rango en razón a su comportamiento, we are talking about an impeachment. When I can do like across or using our legal system or a constitution or a specific administrative law for make that one public actor that can be, I don't know, the mayor of the city, if I can do because of their mistake, I can do that. They go out of the power of my country. We are doing about impeachment process, right? And here we have, okay, here we have other four that are so used in all the international treaties. The first one, limited legal capacity, full legal capacity, international community, and right to self-determination. Este derecho a la libre determinación de los pueblos es la base de todo desarrollo internacional, ¿sí? Es la autonomía, la soberanía, ¿ok? And about the limited legal capacity, that happens a lot of NGO, that they can prove or talk about a specific situation in a country, but they cannot solve it because they are not the nation. They are not representing officially the nation, right? So they have a limited legal capacity. But in the same community, I am the ambassador of Germany, for example, in a meeting, of course that my speech will have like other legal range, and I can maybe take obligations and take other kind of actions just because for my space, for my work, I can represent one specific, or I have the competence to represent one specific topic, and I can help to develop these kind of relationships between nations. We can talk about bilateral or multilateral treaties. Esto, aquí nuestra experta en relaciones internacionales no tiene duda, ¿verdad? Esto es algo que lo utilizamos mucho. Y this is so important. El escenario jurídico internacional, the international legal arena. If in a meeting you have with one of your clients and you start to talk like this, of course it will be so different. The international legal arena. Here and in the most of the cases, I put the websites where I take the information. So here is like a huge and big dictionary when you can start to put specific words and they start to search all around the world in all the databases. What are you looking for, but in a specific context? And it's always so useful. If you want to go deep in a topic, you just go there and start to feel it. I remember that one guy of you that I cannot remember the name told me like, oh yes, I need a glossary because I will starting to study in Florida and I will use it too much. So if you can help me with that, okay, here you can find a lot of information. Cuando nosotros decimos en un espacio legal internacional, en un escenario jurídico internacional, en el ámbito internacional, bien sea para producción académica o producción laboral, en el caso de sus negocios, para hablar con un cliente, para lo que sea que ustedes lo necesiten, the international legal arena is the perfect way to refer these actions. I take like two examples from real life. So in line with the principles and commitments, it has synced onto in the international arena. Algeria reaffirms its strong condemnation of governmental blah, blah, blah. ¿Sí? De conformidad con los principios y compromisos que ha suscrito en este escenario jurídico internacional, etc. Other one, thanks to their success in the field of political and economic transformation, Poland have been assuming the new role in the international arena, right? If we have to talk with a client, okay, Mr. etc. We will represent your case in the international legal arena. We will talk about this specific case in or anti. The thing is that you are so related with private law, so we can talk about a commission or an expertise commission. I will represent you in this international legal arena, but also we can use it for private law in our private legal arena, right? But it's always when we're talking about international law. They can be private or public. So it's important that you have these contexts. I take here one example for a declaration. And my idea with this kind of, okay, 4 minutes. My idea with this kind of parts is that we start to realize and read one specific legal document, that in this case, just because it's international, and we can start to simulate and check how so easy it gets into your mind, into our minds, because we speak English, how it's so similar a lot of words, and how we can understand completely a fully concept talking in legal law, right? So who want to help me reading? Or we want that we read together just for parts.
That's good, in parts.
Okay, so I start because I am the teacher. Who wants to start? Go, go.
The government takes into account the respect for the rights and all races. For instance, the rights to be present equally, the respect for the national and cultural identities, right to autonomy.
Identities.
Right to autonomy.
Yeah, perfect. Next, here is other thing that we can take and we can approach when we are reading this kind of aspects. And it's like all the connectors are so different when we are talking in a formal or legal document that in our daily life. I can talk like, hey, and that's happened, and etc. And then, but in these cases we have, for instance, although, it's like more formal ones. And we can take it for this kind of spaces. For instance, I will represent your claim until the international court. For instance, I need that you gave me to these proofs. I need that you explain to me what happens. I need who will testify in this case. For instance. Lo dije cuando lo estabas leyendo, lo pensé cuando lo estabas leyendo, perdóname que te interrumpa. Ahora, ¿quién sigue? Paula.
Right to self-determination, right to be free from genocide, right to
genocide,
right to consume the assets and natural resources, right to enjoy the developments of both national and international technologies.
Ok. ¿Quién sigue? El tercero, que no me acuerdo el nombre, para eso está en Zoom la cosita con los nombres que me ayuda. Pero que sé que está ahí. Díganme paciencia mientras que me aprendo los nombres. Ah, ya no está.
No está.
Ah, muy bonito. Está acabando clase. Bueno, anotado. Ahorita cuando ya me lista me... Ah, no, mentira. Hasta ahí, ¿qué parte no han entendido?
What's the meaning of assets?
Estamos hablando como de activos, de recursos, de activos. La manera mejor de interpretarla, la mejor como traducción, la más cercana sería los activos. Los activos y los recursos naturales. Hasta ahí, ¿qué otra parte no hemos entendido? The government takes into account the respect for the rights of all races, for instance, the rights to be present equally, the respect for national and cultural identities, rights to autonomy, right to self-determination, right to be free from genocide, right to consume the assets and natural resources. Carla, you go next.
Yes, right to enjoy the developments of both national and international technologies, right to enjoy one's own culture, including one's language, cultural freedoms, rights to participate in national and natural environment protection, right to be free from distinction, division, exclusion, or racial discrimination.
Perfect. I guess that is everything clear. So it's not so different. We have like all this information in our heads. It's nothing so different. And when we are related, this case is just example in international law that is so connected with human rights and these kind of aspects. But the same happen when we when we start to talk about corporative law, because it's so similar. We have just other one or some differences that we want to take it and find it. And individuals. So we talk about non-state actors. Now we are talking about individuals. That is people or corporations who have certain rights and obligations under international law or humanitarian law, or an humanitarian law. Individuals. Okay. The non-governmental organizations like the NGO, organizations that are private, self-governing. Esto es súper importante, el tema del autogobierno, de la gestión, de la soberanía. Lo podemos utilizar para todas las naciones, pero también para las organizaciones a las que nos estemos refiriendo. Non-profit, acuérdense, sin ánimo de lucro. With interest in projects, provide services, defend or promote specific causes, or seek to influence policy. Policy, políticas públicas, public policy, políticas, influir en este tipo de desarrollo administrativo. Non-governmental organizations. The adoption of the text of a treaty, la adopción del texto de un tratado, ¿verdad? Esta es la manera en la que yo puedo decir muy formalmente que dos naciones en un acuerdo bilateral o multilateral, si estamos hablando de más, se sentaron a decir, Pepito quiere exportar bananas a Berenganito y Merenganito quiere exportar café e importar telas, ¿sí? When we are talking, es un caso del TLC, por ejemplo, but we can also talk about the Declaration of Human Rights. For have the adoption of the text of the treaty, we need two specific words here. That is, first one is the approval, and the state establishes the consent to be bound by a treaty in a solemn form. Be bound by, estar obligado por, obligarse con, sujetarse. Sí, la manera romántica de decir estoy atado a ti. Bound by, jurídicamente. ¿Ok? No se les puede olvidar, porque cuando hagamos nuestros quizzes, estas palabritas son las que van a salir. ¿Ok? Ahí vamos. Con este último, que es de vocabulario, vamos a terminar nuestra clase. ¡Oh! Ya acabamos nuestra clase. Bueno, acabamos aquí y seguimos. Si tienen que irse ya, porque a veces tienen otros compromisos, acabamos y a partir de aquí comenzamos la siguiente clase. Se me pasaron 3 minutos. But this is so fast. This vocabulary is so fast. We have the authentication, the exchange of instruments that constitute a treaty. Go back to your international lessons and you know that it's bounded when both parties change the papers, right? El exchange, cuando tú cambias, ese es el canje, a partir de ese momento se constituye un tratado. Cuando Colombia y Ecuador hacen todo el proceso para llegar a una negociación y hacemos ese intercambio, ese canje de instrumentos, a partir de ese momento comienza a ser vinculante. En inglés vamos a decir exchange of instruments. The capacity to conclude treaties, the codification and progressive development. And this is the way we will talk about a specific noun that is Vienna Convention of the Law of the Treaties. We change the order. This is so important. Deposit. What is deposit of a treaty? The one that is or that has the responsibility to take care of the specific document. If you saw some movies from US, you can see that this Declaration of Human Rights is always like so protected with a lot of security services, and it's a lot of people around, and you have a lot of glass that you cannot broken anywhere. You can shut them and nothing will happen. They have, like the US, they have the deposit of the treaty. ¿Y cómo decimos el derecho de los tratados? Law of the treaties. ¿Ok? The law of the treaties. Bien. Todo esto, quedamos, acuérdenme, voy a acordar de acá, de start. Aquí, con esto terminaríamos el martes. A partir de acá, el martes tenemos clase. Les voy a confirmar si el martes tenemos clase o no. Hasta el momento, creo que no.
Ya tienen vacaciones.
Sí. Hasta el momento, creo que no, pero igual todo está sujeto. Todo está sujeto. A eso. Sigan. Ay, no, ya escuché algo, ¿ah?
En Colombia no hay vacaciones.
Hasta el momento nos volveríamos a ver. Yo les enviaría la fecha, porque según el calendario, aparte de esa semana, entraríamos a Semana Santa. Entonces yo les voy a confirmar cuándo terminaríamos este tema, que sería la clase número 3, y les voy a enviar las dos presentaciones, las de la clase 2 y las de la clase 3, para que vengan preparados, y ese día pronto ya resolvemos preguntas y todo este tema. Y mañana en nuestra speaking call, mañana temprano, yo les voy a enviar el material que vamos a trabajar. Ya ustedes vieron cómo es la dinámica, son 15 minutos cada uno. Sé que el primer horario fue muy complicado para ustedes porque los encontré como manejando para la casa y todo este tema. Si quieren, podemos moverlas un poquito más tarde. Yo no tengo ningún problema, tengo mis noches libres, están dedicadas a esto. Entonces, me dicen y lo hacemos un poco más tarde, donde puedan estar más cómodos, donde estén por ahí juntos, haciendo desorden en la clase. Mentiras. Me avisan, no hay ningún problema. Si quieren, podemos comenzar desde las 8 hora Bolivia y nos vamos a 9:30. Así ustedes tienen más tiempo también de organizarse. Entonces, mañana les envío el artículo que vamos a trabajar sobre Derecho Internacional y siempre se van manejando las preguntas. A Nicolás no lo puse a leer porque me imagino que no puede porque tiene el micrófono apagado y la cámara apagada y todo este tema, pero la otra clase me desquito. Bueno, entonces así hemos terminado nuestra clase de hoy. Les voy a pedir por favor que llenen la votación y después de eso, ya, somos elfos libres, nos vemos mañana en nuestra speaking call. Muy importante, y no sé cómo voy a manejar la encuesta de los 3 que están juntos ahí. Porque, o sea, ay, sí, por favor, porque si no después me va a tocar mandar un correo explicando cómo, y entonces se quedaron a hacer una pijamada y por esa razón todos contestaron desde el mismo dispositivo.
Sí, nos conectamos ahorita y...
Pero me toca mientras que está abierta la encuesta, así que estoy aquí pendiente. Listo. Víctor, Esteban, Paula, Víctor, ya los tengo súper identificados. Y Carla, me quedan 2, que ahí los confundo, creo que son 2 bolivianos o un mexicano y un boliviano. Me toca ahí lentamente. ¿Listo? Entonces, así terminaríamos nuestra clase de hoy. Voy a tomar un pantallazo para poder mandar. Así terminaríamos nuestra clase de hoy. Nos vemos mañana para la speaking call. Y el sábado en la mañana les confirmo cómo vamos a manejar nuestros horarios, porque sí o sí el 23 yo viajo y no me gustaría comprometerme y llegar a un lugar donde tenga conexión a internet, todo este tema. Entonces yo les voy a avisar cómo nos vamos a manejar y se mueve un poquito el curso, se mueve un poquito la duración del curso hacia allá. Creería que 4 sesiones, sí, que serían 2 speaking calls y 2 teóricas. Y bueno, muchísimas gracias por su tiempo. Perdón que nos demoramos un poquito más, pero fue porque comenzamos a abarcar otro tema. Que tengan muy buena noche. Descansen.
Hasta luego. Buenas noches.
Adiós.
Chao.
Chao.
¿Sí votaste?